May I please, Your Lordship? Lordship, I beg to mention item number 10, Lordship.
Yes.
Lordship, kindly this matter may take through VC, Lordship.
Take?
Through VC, Lordship, through virtual mode, Lordship. This matter may take through virtual mode, Lordship.
When?
Today, Lordship.
Today. So what's the problem? It will be called?
Lordship.
Yes.
DP apply, Lordship.
Daily list for admission, item 1.
Your Lordship, if 3 weeks may be given for filing our counter affidavit.
Not yet filed.
Not yet filed.
How much time you said?
3 weeks.
3 weeks. For respondent number?
1, 2, and 3. All the respondents. All the respondents.
Okay, 1, 2, and 3. Okay. Please.
H. Lalmal Somi.
H. Lalmal Somi, Learned Counsel for the petitioner. Also had Mr.
Lalvian Sanga.
You have filed Wakalatnama?
Yes, we filed.
Notice has already been issued, Lordship, in the last
Notice
court
already
date.
issued. You have received.
They have already
Okay.
accepted.
Their
Yes,
name has not.
Yes.
Yeah, it's not reflected in the cost list.
Okay. Appearing on behalf of respondent number 1, 2, and 3.
Yes, ma'am.
Prays for further 3 weeks' time to file affidavit in opposition. The prayer having not been objected to by the Learned Counsel for the petitioner is allowed. Accordingly, list the matter after 3 weeks. Stopper. The registry shall reflect the name of the counsel appearing on behalf of the respondent in the cause list. Okay.
Right, Your Lordship.
Oblige.
Item 2.
Lordship, this is a matter of contempt proceedings, Lordship. And the contempt proceeding has been proceeded for 10 years, my Lord. So, on the last court date, my Lord, respondent number 1 is directed to file the compliance affidavit for payment of rental charges 2 crores 16 lakhs. And lately, after
Respondent number 1.
Yes, my Lord.
Respondent number 1.
Respondent number 11.
1 or 11?
11. That is the Central Defense Ministry, my Lord. And so, after 2 months, on June, the respondent number 11 filed the affidavit, but it does not contain any compliance report. It has prayed for dismissal of the instant
Contempt petition.
contempt case, my Lord.
Your Lordship, I appear on behalf of my senior CGC Ms. Zarim Sangpui, and the connected matter WA2 of 2026 is still pending. It was listed on July 22nd, and it was listed again for after a week. So may I pray?
Is there any stay there?
Yes, Your Lordship, it was listed again after a week. So
There is no stay. There is no stay order. Staying the direction.
Your Lordship, as far as I know, that is all the instruction that I could submit to Your Lordship.
Lordship, as per order, contempt order dated through 2nd July 2025, the respondent number 1 is directed to make the payment 2 crores. And after 2 months, on September,
1 or 11?
is my Lord.
To respondent number 1?
Respondent number 11
11.
is my Lord. And so on the next court date, that is 2nd 9th 2025, respondent number 11 prayed for 6 months' time. However, the court gives only 3 months. And the 3 months payment period expired on 2nd December 2025. And on that expiry date of the payment period, on that same date, 2nd December 2025, they had filed WPC in challenging the contempt order 2nd July for payment. However, my Lord, on 10th March 2026, that WPC has been dismissed at the motion stage alone on the grounds that the litigant is trying to mislead the court.
Now the 11, it appears, have already been transferred, and in his place, some other person,
My lord,
incumbent, has joined. The 11,
Lordship,
respondent number 11 has filed affidavit.
Your Lordship,
You have received the affidavit.
Your Lordship,
Additional
I
affidavit.
had received, my lord.
And in this additional affidavit at para 10, he says that the Ministry of Defence, Government of India, is the competent authority with regards to sanction and release of the compensation amount payable to the petitioners, and the respondent number 11 is 11 being a subordinate office. I think this contempt petition is pending since 2016,
Yes, my
for
lord.
about 11 years.
Yes. And the WPC has been filed on 2013. On 2015,
Yes, 15. The order is on 2015.
exactly,
But
19 March
it appears
2015.
that it has not yet been complied, because this officer who have been posted here as respondent number 11, now 12, all these doesn't have the power, a sanctioning power.
But they have to pursue. They have to. Yes,
but
my lord.
pursue.
Yes.
It appears that instead of pursuing, why don't you implead them? Instead of this person saying that we are not the authority, we are not the sanctioning authority, why don't you implead straight away the authority? Because there is order 2015.
But my lord, so far so good. They had attend and they had.
See, they are see why they have not yet paid for 11 years. Because they are this way, this plea or that plea, they are prolonging the payment. And then they are being transferred here for temporarily for 1-2 years. They goes, you have to implead another officer again,
Yes, my lord.
isn't it? So how long it can be? So instead of that, let the respondent CGC to identify the hierarchy of the officer, authority,
my lord.
who has a power and authority and sanctioning power.
my
You plead them straight away.
Yes, my
That
lord.
will be better. It appears.
My lord. Anyway, my lord. This
Because this now this authority, present authority, respondent number 12, will also say the same thing. I am pursuing.
Yes, my
But
lord.
then since the sanctioning authority is the Ministry of Defence, government, so let the respondent find out the authority, exactly who is the authority to pay, release, sanction, okay, then implead them straight
my
away.
lord.
That will be better.
Yes, my
Because
lord.
now you see, and then what do we want is we want that the contempt that they should comply with. No point putting them inside, and it's very difficult also because they are not a sanctioning authority. If the sanctioning authority deliberately does not comply, then they will face the consequences.
My lord.
But okay. Yes, Ms. Jairam Sangpui.
My lord.
So it appears because in your affidavit filed by the respondent number 11, it appears that he is not the authority. He says that the Ministry of Defence, Government of India is the competent authority with regards to sanction and release of the compensation amount payable to the petitioner as per the direction. So that means the officer who are being posted here are not the sanctioning authority, not the proper authority to comply with the direction of this court, isn't it? It appears what he says. Para 10. He only says that he is subordinate authority, subordinate officer, and does not possess the independent financial or administrative authority to release the said amount. and the approval authority and the sanctioning power is with somebody.
Being a post of this defendant state officer, my lord, he has no a full power.
Yeah, that is
He
why.
just stated that he has no full power.
That is what I am suggesting.
Ah.
The learning counsel for a petitioner is to implead the authority who has a power.
My lord, it
Because
already-
unless he has been he is impleaded, the officer, subordinate officer will always say that we are pursuing. Subordinate authority will always say that we are pursuing. And despite of our all efforts, if they are the sanctioning authority
yes, yes.
doesn't release, what can we do? This is what I did. In the same way, this respondent number 11 is also saying what he has taken steps. He sincerely has tried to pursue, but then ultimately he failed. And now he is facing the consequences. So how long it will continue? Since this has been continued since 11 years. So why don't you just figure out the correct right authority and then the hierarchy of the authority, who has the sanctioning power, so that the petitioner implead him.
My lord, the letter has been sent by DO to the principal director, the page number 14.
Sent by
Sent by DO, defense.
What is this?
Officer,
What
who filed
letter?
affidavit, my lord.
Hmm?
Who defense
proposal for
officer-
payment.
Yes.
Who is this authority? Power IDG. ID.
It was
Ah,
written
yes.
in Hindi, my lord.
Raksa Sampudam. Letter has written in English and then his name, address, everything written in Hindi.
Yes, that the defense estate office sent to the principal director DE for approval, my lord.
What it says, the letter?
Proposal for payment of rental compensation.
2
for
crore
the
14
letter.
lakhs. He has also,
Yeah, in the last.
this is from
sentence.
Gauhati.
Yes, it is from.
This
Gauhati.
authority is at Gauhati. Whosoever may be, wherever, Gauhati or Kolkata, wherever may be. But then the person who has the right and authority to sanction should be impleaded. Otherwise,
It
will.
seems that the principal director,
Hmm?
the principal director, the Government of India Ministry of Defense, Eastern Command,
Principal director.
to whom letter has been sent by the DO.
So what does it says? Are they going to pay within short period?
That PD may not be
It's
a
only
party,
proposal, you see.
may not be a party. in
Order
the-
was passed 2015. Now only proposal is going on.
No,
The
my lord,
contempt petition is
the
pending since
the
2016.
The verification team has been made a decision lately, my lord, 2023 only.
So what is your submission now?
My lord, now the connected case has been pending at division bench. The
No,
outcomes
there
of
there
that-
is no stay, I'm told. There is no stay there. This will proceed unless there is a stay. The contempt will proceed, isn't it?
If I may permit it some more time, my lord, then I'll clarify who is the paying authority. Who is,
Okay. Okay, so that he implead
Yes, yes.
the right authority. Okay. Mr.
Reuben, Lauren Sanga. Reuben.
Okay, land counsel for the applicant stuff. Also heard Miss Jaram Sampur, land counsel for the respondent number 2, 4, 8, and 11. 12 also? 12 also?
2, 4,
Are you
8, 11 and 12.
representing respondent number 12 also?
Yes, my lord.
Okay, thank you. 2, 4, 8, 11 and 12.
Exactly.
Para. The respondent number 11 has filed additional affidavit in person to this court's order dated 6/4/2026, passed in, no, this is, okay, 6/4/2026, wherein at para 10, he stated that the Ministry of Defense, Government of India, is the competent authority with regards to sanction and release of the compensation amount payable to the petitioners. And he being a subordinate officer does not possess independent financial or administrative authority to release the compensation amount without approval and sanction from the competent authority. Stop. Para. It appears that this will come first. Okay, I'll change later. That the affidavit filed by the respondent number 11 is not the compliance of the order, not an affidavit, for compliance of the order. However, he only narrated the steps he has initiated pursuing the higher authority for payment of the compensation as directed by this court. Stop. Para. It appears that the same plea has been continued since 2016, resulting the compliance of the order, compliance of this court's order remains uncomplied. Sorry, the direction of this court order remains uncomplied. Stop. In view of the above, Ms. Jarung Sangpui, learned counsel for the respondent, shall identify the real decision maker. No. Shall, huh? Furnished the administrative hierarchy of the authority, of the respondent authority, identifying the authority competent to grant sanction and release the compensation in terms of the judgment and order of this court dated when
19th March 2015.
19/3/2015. Stop. By the next date. Thereafter, the petitioner shall take appropriate steps for implementing the appropriate authority in the contempt application. Stop. As requested, list is, well, how much time? it
3
will
weeks
take?
may be given, my lord.
3 weeks.
Yes, my lord.
Okay, as requested, comma, list matter after 3 weeks. But you should ensure that in the meantime, you should file the hierarchy by way of filing affidavits, additional affidavit.
Yes,
These are the authority, and after receipt of that, you should file. You
Okay.
may file implead the authority.
my lord.
That will be better
Yes.
because now the same thing it will remain. Okay.
Deeply
List matter
obliged.
after 3 weeks.
Obliged.
Okay.
Item 3.
My lord, for the petitioner, as per the last order, except respondent number 2, the other respondents, they haven't filed their affidavit.
Yes, they have not filed. See, who appear for the respondent?
My lord, I'm appearing for my senior respondent number 6. So
You
we'll
are
be
for six?
filing, yeah, and we'll be filing our counter affidavit during the course of the day.
My
You are
lord,
for 6. Who else?
I'm for respondent number 1.
1. Okay.
Your Lordship, I'm appearing on behalf of my senior respondent number 2, my lord. We have already filed our affidavit.
Not yet. Huh?
We have filed our affidavit.
You have already filed.
Already filed, my lord.
Okay. And then 1, 2. What about 3, 4, 5?
The state respondent, she's on legs in
Okay.
another court.
Whether the state have filed? Not yet.
Not that.
Okay. Hard miss.
Biral Ramnemi.
Land counsel for the petitioner. Stop. Huh? 1 is. Who is for 1? Mr. For 1. Okay. Land counsel appearing on behalf of the respondent number 1 and Miss Jaram Pui. Jaram Sampui, Land counsel appearing on behalf of the respondent number 6.
I'm for 1, my lord. I'm for respondent number 1.
Oh, you are for 1. Okay, you are for 6. Okay. Our name should be first, huh? For respondent number 1 and Mr. his name appearing on behalf of the respondent number 6. Praise for. How much time is it? How much time you prayed for? Affidavit? Okay. And then what about
I will
you?
be filing my affidavit, my lord, since I didn't receive instruction in this regard.
Instruction not yet received. So you are praying for how much time?
2 weeks may be given.
2 weeks. Okay. Then separately, huh? Sangpui, huh?
Your Lordship,
Jairam Sangpui.
if it can be reflected in the order that the counsel for NHIDCL is out of station due to his mother's illness, my lord.
NHCL is respondent number?
2, my lord.
Okay, 2. But you are there. You have already filed.
Yes, my lord.
Okay. Not required since you are present. Okay. Praise for further 2 weeks' time to obtain instruction and to file affidavit in opposition. Stop. Mr. Swenso for respondent number 6. Huh? Praise. So some is that the affidavit is ready and he will be filing the affidavit on behalf of the respondent number 6 during the course of the day. Stop. While Mr. and counsel appear on behalf of the respondent number 2. Some is that the Mr. Swenso is also present on behalf of the respondent number 2, who submits that they have already filed their affidavit. Stop. Huh? Okay. Please pray for, comma, list this matter after 2 weeks. Okay.
Item 4.
Your Lordship, here I am for the petitioners and the state respondents are here to file their counter affidavit.
Yes, you are also not yet filed. So,
If your lordship permits me another 3 weeks' time to file my affidavit in position, I have not yet received the parallels from it, your lordship.
you have not yet?
Received the parallels from it.
Okay. So how much time you
3 weeks time.
hmm?
3 weeks time, Your
3
Lordship.
weeks.
3 weeks.
Okay. Mr.
Seatlan Thiang Lim.
Land Counsel for the petitioner. Stop. Miss Land Government Advocate. Not Government Advocate. This is okay. Land Government Advocate for the
Respondent
state
number 1
respondent
to
number.
6. 1, 2, 3, 4, 5, and 6.
Okay, 1 to 6. Praise for the 3 weeks time to obtain necessary instruction and to file affidavit in opposition on behalf of the respondent staff. The prayer, okay, the prayer is allowed. The prayer having not been objected is allowed. Okay, accordingly, list the matter after 3 weeks.
Item 5.
Here also same papers. Yes, who appear for the petitioner? And for the respondent? You have not yet filed affidavit. Similar order? Okay. Who appear here otherwise? Well, Mary.
For the petitioner, it's
No,
Miss-
no. For the respondent?
For the respondent, Miss Lalundui.
Okay. Okay, Miss Senso appearing on behalf of Miss Lal Nunu Louis, Lana Government Advocate. Prays for further 3 weeks time to obtain instruction and to file affidavit on behalf of the state respondent. Stop. The prayer is allowed. List the matter after 3 weeks. Okay.
Item 6.
You say none appears on behalf of the petitioner, right, in the beginning. However, Miss So-and-so appearing on behalf of London Gui. Yes, who appear for the petitioner?
May I please your lordship?
Yes.
On the last occasion, this honorable court directed to serve notice upon the respondent number 3 through speed post, and the same has been taken.
Okay.
But
Respondent number 3.
yes, lordship.
It was insufficient address. After that, you have taken steps.
Yes, lordship. It is address is Bhenglai Aizol.
Okay. In the new address, you have
Not the
taken
new
steps
address.
in the new address of the respondent number 3.
No, the address reflected in the writ petition on
But then
that address.
there is insufficient address in the earlier steps. Okay.
Yes. Steps has been taken for only one time.
No house number, nothing. Only resident of some village. How it will, how the postman will find out.
Or lordship, only that much information we have.
You have to find out.
Yes, lordship may allow us to verify the full address and take step upon fresh step upon the respondent
Okay.
number 3.
Mr.
KK Medhi.
Land Council for the petitioner. The office note dated 8/5. 2026 reflect that the notice upon the respondent return unserved with the postal note RTS insufficient address. Stop. In view of the above, the Land Council for the petitioner prays for allowing him to ascertain the correct address of the respondent and to take fresh steps. Stop. Fresh steps upon the respondents be taken by a speed post within a week from today. Well, within a week? Or
Within 2 weeks. 2 weeks. 2
Okay,
weeks.
within
Lordship.
2 weeks from today. Okay. Least a matter after 3 weeks. Okay. After 4 weeks. Okay.
Mat Prakash.
Item 7.
Please, Your Lordship.
Yes.
My Lord, in this case, I'm for the private respondents number 3 to 122.
3 to
122. 122. All the private respondents.
just a minute. Who is for the petitioner? No one.
My learned friend
I am-
appearing through VC.
Okay.
So, Your Lordship, in this case, as a preliminary objection, I would like to raise the maintainability of this writ petition. The reason being is that, Your Lordship, our lands were required for the construction of the railway line here in Mizoram. Thereafter, some landowners, they filed a reference praying for enhancement of the compensation amount. That was allowed. So accordingly, the present private respondents herein, we invoked section 28A of the Land Acquisition Act of 1894, praying for similar benefit.
Just a minute. You are for respondent number?
Number 3 to 122.
Oh, okay.
All the private respondents. All the private respondents are being represented by myself.
Okay.
So our lands were acquired for the construction of the railway line.
You file affidavit?
Not yet. So as a preliminary objection, I'm raising the maintainability of this writ petition.
Okay.
So if Your Lordship may kindly bear with me. What I'm trying to say is that this writ petition is not maintainable because they have to file an appeal under Land Acquisition Act.
Are you filing any affidavit?
So before I go into the merit, Your Lordship, I'm raising the maintainability on the legal ground.
Raising mentality.
Yes.
Just verbal.
Verbal.
Okay.
If Your Lordship can kindly indulge with me, it's on the legal point, it's on the law point.
Okay.
On the law point. So our lands were acquired, compensation paid. Other landowners filed a reference praying for enhancement. That was allowed. Accordingly, I also filed section 28A application praying for similar benefits. Again, that was allowed. This can be found at page number 51. This is before the additional district judge. Judgment and order is passed. Page 51 is the relevant portion. Your Lordship has the judgment and order. So this is the judgment and order. As per this judgment and order, a direction was passed to the district collector to make assessment. Please prepare the assessment report, and after that, the railways will pay the necessary amount. So accordingly, they are now challenging page 57. This is the assessment report of the DC. They are only challenging this page 57, which is redundant because they have already paid the amount.
They only pay?
They have already paid the amount and yet they are challenging it, which is
Okay,
redundant
already
now.
paid?
They have already paid this page 57 assessment.
After
They're-
after payment?
They are challenging.
What is their prayer then?
So for setting aside this page 57 and page 68.
And thereafter?
Only that much. That is their limited prayer. Their prayer is at page 57 and 68.
Just a minute. Let us see their prayer. Set aside quasi impugn letter.
The two letters.
Just a minute. Huh? 25/7. And which one is 14/1? What is this?
This is at
14/1?
page 68.
68.
Yes.
Just a minute. Huh?
Yes.
Page 57. What is this page 57?
Page 57 is the assessment made by the DC pursuant to the judgment and order of the additional district judge.
Okay, assessment, and then these are the least.
Correct. List of the
Okay.
these are the present private respondents.
Okay, and then thereafter 68 is.
68, Your Lordship. What happened was that the DC missed out to calculate interest payable under section 34.
Okay.
So that was included in this page 68. So what at this point what I would like to mention is that, Your
No,
Lordship.
so this page 57,
Yes.
assessment already paid.
Already paid.
When?
This was sometime 2 years back, Your Lordship. I'm not
2 years
very sure
back.
of the date, but
And then-
we have received it.
And what about this to page 68?
68, we are yet to
Last-
receive. We are yet to receive this column number 11 and 12.
What is this column?
This is the
number 11,
interest,
sir?
interest on delayed
I
payment.
mean, otherwise you have received.
Otherwise, we have
Only
received
interest is.
interest on delayed payment is yet to be received.
Interest is yet to receive.
Yes. So at this point, Your Lordship,
So they are not releasing interest.
yes. So they're challenging this letter as well.
Okay.
So at this point, Your Lordship, what I would like to point out is only two things, only 2 points, only 2 legal points I would like to point out.
Just a minute, huh? 57. 57 already paid.
57 already paid. We're not bothered with that
Only
anymore.
14. No, 14 means.
57 already paid.
68.
We're not bothered with that. It's a
68.
redundant.
Only interest part.
68 only interest part is not paid. Otherwise, everything else is paid.
Okay, but then since they have challenged this,
Correct. So I am
what they
saying
what they says about the interest.
they are saying that they're not liable to pay interest. That is
Okay,
let's
but
put that let's put
The
that
payment of the compensation is enough
according to them. Yes.
according to them.
They are
So
not
that-
liable to pay interest on delayed payment. For the delay, they are not liable to pay interest. That is their basic case.
Okay, so that
On-
now the interest part, if they have challenged, you have to contest.
Let us forget the merit of the case for a moment. Let us forget the merit of the case. What they are saying may be correct. I don't know. That we will. I will leave it to this court. What I am raising at this point is these 2 letters are consequential orders. These letters were issued by the DC in consequence of that district judge judgment in order. They have not put to challenge on that.
No, see, now 25/7/19, page 58 is
Yes,
gone.
gone.
Already paid.
Gone.
Nothing remains.
Nothing
But then
remains.
he is raising interest part.
Correct.
That
What I'm
you are
saying-
not liable.
So
Yes,
what,
yes, sir.
what
They are
I'm
not
trying to
liable.
say, what I'm trying to impress upon your lordship is, this is pursuant to the judgment and order passed by
No,
the additional.
payment at page 57 is pursuant to the judgment.
Even 68.
Even 68 is only interest part.
Correct.
Whether interest, they are.
No, there
they
was
say
a
that
direction to
according
pay
them-
interest also.
Directed in the interest.
In the
interest
judgment and
also
order, there
directed.
was a direction
Can
to
you
pay
just see
interest.
once again? That part.
Lordship, we are not against the judgment. Lordship, may I
Correct.
please?
So exactly. So he is
Then-
he is admitting that they are not against the judgment.
Then
What is there?
what
is left?
what remains?
Lordship, let me satisfy your
Just
lordship.
just
Lordship,
just a minute.
no,
One second. No? Just where is the direction regarding the interest
At
in the
page
judgment?
55, your lordship.
55.
Yes. Para 7.
Para 7.
Yes. May I read, your lordship?
Yes, please.
At this stage, it may be pointed out that since the appellants are equally entitled to all the benefits as given to those other landowners who were petitioners in LA case number so-and-so and LA case number so-and-so, the district collector shall give the same benefit to the applicants as they are entitled to the same benefit as the other landowner, pertaining the same notification and award. In addition to the said benefits of payment of the cost of the land at so-and-so, under section 23 and solatium under section 23(2) of the said act, they are also entitled to payment of interest under section 28 and 34. So direction is there. He is saying that he has no problem with the judgment.
Okay.
Then what else remains?
Then if you are not challenging,
They have
or
not
agreed,
challenged.
if you are not agreed by the judgment,
Then what is there to adjudicate?
on what basis?
Lordship,
They-
may I?
So,
Yes.
lastly, Your Lordship, just,
okay.
I'll
Just
just
a minute,
complete.
just a
I'll just
minute.
complete. What I'm trying to say is that even if they are aggrieved, even if they are aggrieved, the writ jurisdiction of this court is not the correct forum. As per Land Acquisition Act, Section 54 provides for appeal provision.
Yes,
They are supposed to file an appeal against the judgment in order,
right.
not come
But
by way
they are not
under.
agreed by judgment.
Correct. So they are saying that I am not aggrieved with the judgment in order, but I am aggrieved with the letter that was issued pursuant to the judgment in order. How can you do that? It has to be either this or that.
Yes, what is your submission?
Lordship, may I have a look at page number 55, the operative portion of the judgment. May I read, Your Lordship?
Yes,
In addition to the said benefits of payment of the cost of the land.
Where are you reading? Page?
Paragraph number 7,
okay.
page number 55.
Yes.
In addition to say the said benefits of payment of the cost of the land at the rate of ₹25 per square feet, interest under section 23(1)(a) and solatium under section 23(2) of the said act, they are also entitled to payment of interest under section 28 and section 34 of the said act. We agree that the landowners are entitled to payment of statutory interest under section 28 and 34 of the alia. But we are challenging the calculation of the assessment letter of the calculation of section 34 interest, Lordship. Lordship may have a look at
Where
page
have they
number
mentioned that in the writ petition?
Lordship,
They have not mentioned this in the writ petition. How can he make submission beyond his pleadings?
Where is your pleading? Let us see. Which paragraph?
There is nothing on calculation.
Calculation, then appeal lies. If it is regarding
Correct.
calculation.
So let them file an appeal under section 54, not under 226.
Lordship, may I satisfy you, Lordship?
Which
Lordship
paragraph?
may have a look at page number 18. Page number 18, Lordship. Page number 18, paragraph number 8. That the petitioner state that interest under section 34 of the alia Act 1894 applies to the original compensation amount determined by the collector under section 11. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall be under obligation to pay the amount awarded with interest from the time of taking possession until it has been so paid or deposited. In the instant case, the initial land value was 0. Moreover, the amount as determined in draft award number 1 of 2012 had been paid by the railway before taking possession. As such, railway is not liable to pay. Then Lordship may come to paragraph number 9 also, that the petitioner state that statutory interest under section 34 of the alia Act 1894 in the present case comes from the date of award relating to the land value under section 23(1) of the alia Act 1894, because in the present case land value was 0 when compensation under section 11 of the alia Act 1894 was determined. Therefore, statutory interest provision under section 34 for interest never attracts to that effect. Lordship,
So they agree with the
there are
judgment.
two cases.
They
Lordship,
agree with the judgment. Let them file an appeal.
Lordship, first, Lordship may hear my submission. Thereafter, my learned friend if they have any objection, then they can raise it. Lordship, there are two phases. First, draft award. When the draft award was passed, there was no land value. There was no land value. Therefore, thereafter, the reference court enhanced their land value at the rate of ₹25. So our submission is that the statutory interest since from the passing of draft award to the passing of judgment by the reference court, there was no land value. That's why railway is not liable to pay statutory interest under section 34 during that period. Then we agree that the landowner are entitled to payment of statutory interest under section 34 from the date of passing of enhancement award by the reference court to the subsequent payment by the railway. That's why we are challenging the assessment made by DC. In the assessment, DC made
For the assessment.
interest from the Yes, from the date
If
of
you are
possession, yes.
if you are aggrieved by the assessment of the interest,
Yes.
is it the writ petition? Is it the writ court?
Yes, because assessment was passed by DC. We are not against the judgment of reference court. It was passed by, assessment was made by DC. The Lordship may have a look at page number 69 of the writ petition. In the assessment, the DC counted the statutory interest under section 34 from the date of possession. And according to us, they are entitled to interest from the date of judgment passed by reference court. That is the main thing. And Lordship similarly situated, there are 3 writ appeals pending before the principal seat Gauhati High Court regarding this section 34 statutory interest, whether the landowners are entitled to payment of statutory interest under section 34 from the date of possession or from the date of judgment passed by reference court. That regarding that matter, 3 writ appeals are pending before the principal seat and 2 writ appeals are pending before the Aizol bench, Lordship. Only that thing. We are not against that. Yes, they are entitled to get statutory interest under section 34. But the
So that's what we say,
period
we want the section 34
Regarding the calculation, according to you, where it lies?
My lord, in my humble opinion, you cannot challenge the consequential order without challenging the principal order. The principal order is a judgment in order.
No, in the principle,
it says it's a wrong calculation. Wrong
Correct.
calculation.
So that's what I'm saying, Your
Lordship.
Lordship. Even if
With
they are
regard to the
aggrieved,
calculation only,
if
if
they
they
are
are denying the
aggrieved.
interest also.
my lord, this Land Acquisition Act is a complete code. It's a complete code in itself. It contains procedures for how to acquire land. If you are aggrieved, how can you ask for enhancement? What type of
Enhancement also is not challenging.
So that's
Only
what I'm saying.
only the
Yeah.
calculation part.
Correct. Even to challenge the calculation,
So,
section 54, Your Lordship. Kindly look at it, section 54. Section 54 of the Land Acquisition Act 1894. Can the writ
There
court
is a-
substitute its appeal provision is there? Let them file an appeal. This is not the correct
That
forum.
is why I'm asking.
Appeal provision is there if we are agree with the judgment passed by the reference court. We are not against the judgment passed by the reference
Because
court.
the award was
In the
passed-
judgment
award was
by-
passed
in
under
the
this act.
judgment- In the judgment, honorable reference court only directed to pay interest under section 28 and section 34 of the LA Act. But the period, whether it may be from the date of possession or whether it may be from the date of passing the enhancement award, it is not reflected in the judgment.
It has to be an
We are
appeal, my
not
lord.
against the judgment. We will give the landowners statutory interest under section 34. But we are against the calculation. We are against the DC counted it from the date of possession, and this method.
So
is
according to
pending.
you, calculation is incorrect.
Yes, Lordship.
Okay, then-
because Lordship may.
Who calculated? Who calculated?
Sorry, Lordship.
Who calculated the interest?
Interest is calculated by DC.
Okay.
DC.
They have not submitted a single representation to the DC also.
Have you submitted any representation against this wrong calculation?
No.
Yes, it is not in the writ petition. Then Lordship may next week Lordship may.
Why?
pick the
No,
matter
it doesn't work like
next
that.
week.
It doesn't work. They have to withdraw the writ
No.
petition.
Have you made any representation against the wrong calculation made by the deputy commissioner? Why straight
I am
away
for-
to the writ court? Can the
I
writ
am
court
not-
recalculate? Calculation, if it is a arithmetical error, then it has to be a deputy commissioner only who has calculated.
Yes, deputy
Then-
commissioner was.
Then why you have come before the High Court?
Because payment is made by railway.
Oh, Land Council, you say that it's a wrong calculation. There is an arithmetical error in the calculation.
Yes,
Who will recalculate?
DC will calculate.
Then, have you made any representation before Deputy Commissioner?
That I am
Have
not
you
aware.
pointed out the incorrect calculation before the Deputy Commissioner? He would have corrected had you made one.
Then Lordship may kindly fix it on tomorrow. I will.
Why?
I will,
Why?
I will
It doesn't
call-
work like that. It doesn't
fix
work
it
like
on-
that. There cannot be a parallel proceedings.
or at 2, Lordship. My senior is on leg before the principalship, Lordship. Or if Lordship allow on at 2, Lordship, or tomorrow, Lordship. My senior will appear to BC, Lordship.
You can take it up on Monday.
Monday?
Take it on Monday.
Okay, Monday? Okay.
Yes, Lordship. Sure.
Hard, Mr.
Dalfakoma.
Your good name, please.
Mine, Your Lordship.
KK Methi.
KK? Land Council for the petition.
KK Methi.
Okay, Land Council for the petitioner. Also heard, Mr.
Dalfakoma.
Land Council appearing on behalf of the respondent number.
Private respondents.
Okay, for the state. Okay, Miss. Okay, Land Council appearing on behalf of the respondent number 1 and 2. And who is 3? Three is also private respondent.
Yes, I'm for 3, 2.
Okay, 3, 2.
1,
Sorry,
3, 2,
1 and
2,
2.
2.
Huh? And Mr. So and so for respondent number 3, 2, 120.
2. 122.
122. Stop, para. On the pray, is prayed for by the Land Council for the petitioner. List is matter again on Monday. Okay.
Deeply obliged.
Lordship, interim, there is interim order that may be continued.
What interim?
They've already paid. What interim, my lord?
Only for 3 days, Lordship. On Monday,
Interim is
on
for?
Monday, assessment made by DC that was stated by this honorable.
There is no execution. There is no execution case, my lord.
14. Okay, the interim.
My
Interim
execution case is pending.
continue
Execution
in
case is-
respect of 14 only. 25, 7, 19 already paid. What interim? Okay,
the
anyway,
assessment
in
of
the
the-
meantime,
No problem.
the interim order passed and they shall continue. Okay, no problem. We'll dispose of on Monday.
Obliged, lordship.
Much so.
Item 8.
Your Lordship, on behalf of the state respondents number 1 to 5, I am yet to receive instructions from the department. If I may be granted another
Okay, Miss.
Caroline K. Lungoypui
Yeah,
for the state respondent number 1
Land Council.
to 5.
Land Government Advocate for the state respondent number 1 to
1, 2, 3, 4, and 5.
5. Submits that she is yet to receive instruction to file affidavit in opposition. And therefore, she prays for how much time you said?
3 weeks time.
Further 3 weeks' time to obtain instruction and to file affidavit in opposition. To which Mr.
Stephen Lilbot said.
Land Council for the petitioner has no objection. You are for?
For respondent number 6 on behalf of my senior.
Have you filed affidavit?
No, no, my lord.
Are you going to file?
I'm not sure. So I'm
Okay. No, Mr.
Timothy Laden-
Land Council appearing on behalf of the respondent number 6 made a similar prayer. Huh? Stop. Huh? Mr. His name. Mr. Land Council for the petitioner. He is present and has no objection to the prayer made by the Land Council for the petitioner. Stop. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship, if a specific date may be given.
Okay. Specific date. Then when?
20th of August.
27. Okay, August. Okay.
An
Prayer
interim
is
order,
requested.
prayer for interim order
There,
may be heard on
there
that
is
date.
interim.
No, no.
Okay.
Prayer for interim order may be heard on that date.
Okay, on which date the interim prayer shall be considered. Okay.
Obliged, my lord.
Orders. Item 9.
May I please, your lordship?
Hmm.
I'm appearing
Yes.
on behalf of my senior, Mr. Lal Bignunga Namtea, who is having difficulties today, my lord. If the matter may be taken up on 10th of August,
10 of August.
yes, my lord.
Just a minute. Huh?
I have no objection, my lord. I am for
Okay.
the sole respondent.
Mr.
Mal Sabdong Zela Tilu.
Hmm?
Mal Sabdong Zela Tilu.
Okay. Your name is there?
Yes, my lord.
Which number? Land Council. Praise for. But your senior is?
Mr. Lord Bigno and Namta.
Okay. Labyak Nunga. He is? Where he is?
His difficulties today, my lord. Medical problem. He's having medical issue.
Okay. Some Mr. He is senior Mr. Labyak Nunga. Amte. Land Council for the appellant. Has some medical issue. Therefore, we pray for adjournment of the matter to be listed on 10th August.
Yes, my lord.
To which Mr.
Si Tlan Tian Lim.
Okay. C. Trang Tiang Nima, Land Council for the respondent has no objection. Accordingly, the prayer is allowed. As requested, list matter on 10th August.
In the admission column, my lord.
In the, for admission.
Yes.
Okay.
Item 10.
I have filed my objection, my lord, which I believe is not placed on the court, lordship. So that may also kindly be called for, my lord, and may be taken up next week, my lord.
Who is for the petitioner?
I am appearing for the petitioner, lordship. Can it be taken up on Monday, lordship? If they have filed their affidavit, can it be taken up on Monday? Because here, lordship, I am paying bail on the ground that
No problem.
he was not.
Monday?
Monday or Tuesday, either day, my lord. It's up to your lordship.
Okay. Mr.
Yeah, Azad Ahmed.
Ajad Ahmed, Land Council for the
Can we
petition.
have it, my lord, on Tuesday, my lord?
Tuesday?
Tuesday, my lord. I have some other item fixed on that date, on Monday, my lord. So if it may be taken up.
Say
on
Tuesday.
Lords.
Okay. Also had Mr.
C. Joram Chang.
C. Joram Chana, Land Council appearing on
Respondent number 2.
Land Special PP for the Special PP.
My.
Okay, for Special PP for
NCB, my.
NCB.
NCB.
okay, ACB.
And respondent number 1 is the
Who
state.
submits that he has filed objection.
My
You have filed objection.
My lord.
Stop. Huh? Yes.
Your lordship, respondent number 1 is the additional PP, Miss Vanessa, when she's annexing the other court.
Okay. In any case, we are fixing. Okay, good. Tuesday. Okay. Whether she has also filed any objection? No. Whether record was called for here?
No, record was not called for, lordship, in this case.
What is the stage of the case? Investigation or
Application.
So the charge sheet already filed in this case.
charge sheet already filed?
Charge
What
sheet
is
already
the
filed.
status of the case
I am
then?
paying.
Charge sheet.
I am paying
filed.
for bail.
Supplementary charge sheet, my lord, also filed now.
Supplementary also charge
Also
filed.
filed. And
So,
both of which, my lord.
pending
may-
before the PC court,
Yes, yes.
Special Court PC
of
Act.
Indian PS Act.
Okay.
So those record may kindly be called for, my lord.
Then can it come on Monday?
Tuesday.
Which court? Where?
Special
Which
court,
district?
Aizol, my lord.
Aizol.
Here, my lord.
So on Monday, will it reach?
Tuesday, my lord.
Tuesday, will it reach?
I think so.
Okay.
Or can we have it on Thursday, my lord? Because there might be some.
See, the record need to be called for.
No, here in this case, lordship, what I am paying for bail, lordship, on the ground that non-compliance of section 47 and 48. If I raise this issue, that prosecution has to.
But the
prove that
record
they
need
have
to be-
complied.
Yes, there are
No,
records
prosecution
which
has
shows
to
that
prove
compliance
prove
is
that
there,
they
my
have complied. So accordingly, they have filed their affidavit. Lordship will see into it from it. If it is necessary, then your lordship can call
No,
for
those
the
records will be available,
Record is
those
required.
documents will be available on records only.
available with the
Whether
prosecution, because
they complied or not, will be available on
Yeah.
record only. Record
it
need
will
to
be
be called
record,
for.
it will be available with the prosecution. If they can prove that they have complied with, then I have no case, lordship. Otherwise, if required, lordship will see. a
Record
call
will
for the
show,
record.
my lord, record will show whether we comply or not. So
Okay.
record is necessary
Okay.
to be called.
It is submitted, the case has already been, upon completion of investigation, the case has already been submitted into charge sheet staff in view of the above. Call for the scanned copy of the trial court record. Okay? stop, list, as
Thursday, my
requested,
lord.
comma, list matter on
Tuesday, Your Lordship.
It's up, I cannot say, my lord, whether on Tuesday that record will arrive, my lord. So there might be some problem. So we have, if we have it on Thursday, it will be okay, my lord.
He submitted on Thursday, the record will be able to produce. Tuesday, not sure.
Not
So
sure.
let us be sure then on Thursday, okay?
Your Lordship,
Yes.
I leave it up to you.
Okay, list matter on Thursday, 6th. That is 6th.
Lord.
My lord. Obliged.
Obliged.
Item 11.
My lord, I'm for the appellant. My lord, we have been permitted by this honorable court to take a step against respondent number 3 by way of dusty. However, my lord, we couldn't track the exact location of respondent number 3 since he's staying in Longklai district, which is about 269 kilometers far away from Aizawl.
You ascertain the proper address and
Yes,
we'll grant you some more time.
Yes, we are trying to ascertain the proper address,
Okay.
but we still are unable to
Okay.
know the exact
Take
location.
the assistance of the assistant, your other friend in that district.
The district court. Yes, maybe we could
Or,
also.
or so the district court where the legal services authorities are available, and then requesting them, making an application to find out through the paralegal volunteers to find out the address of the, okay, or through the police, whosoever is convenient, okay? Mr.
Valal Ranpuya.
Learned counsel for the petitioner submitted, although he was permitted, the petitioner was permitted to take steps upon the respondent number 3 by way of the dusty. However, he could not ascertain the proper address of the respondent till date, as the respondent is stated to have been living in which district you said?
Longklai district.
Longklai
district.
Longklai district, which is about
269 kilometers. 269 kilometers away
269
from Asia.
kilometers from Aizawl. Stuff. Therefore, he prays for further 3 weeks' time to ascertain the correct address of the respondent.
Respondent number 3 to be specific.
2.
Respondent number 3.
Or respondent number 3. And thereafter to take steps. The prayer having not been objected to by Mr.
Sitlan Thiang Hima. I'm for the respondents number 1 and 2.
For the respondent number 1 and 2 is allowed. Stop. Is requested. Come on, list the matter after 4 weeks. Okay.
Obliged, my lord.
Well, granting you 4 weeks, you ascertain?
Deeply obliged.
What about the hearing? Okay. What about 7 was to be the other day or the yesterday, probably the 6 and 10. Okay, 7 was also ready, probably. No. Oh, adjourn. Okay, then in that case, finish. Okay. Okay.